Hello all. Today we will discuss about the price code, which is an important topic of international law. I hope this is for a short question. It is important. Let us discuss what is price code. Firstly, I will tell what is price. Next slide. It is defining what is price. The property of an enemy which is captured in the sea or in port is called the price. Here the property include the vessels and all goods within it. So this the price code. Firstly, price. It may be defined in the violation of the blockade, which you have already done. Blockade. When a ship of other state having goods or property, then the belligerent state can seize that ship or the ship with the property that it is called the prize. Prizes, therefore, are different from the property which is captured on the land. The latter is termed as the booty. Belligerent state does not acquire the ownership on the property that is prize, but for deciding the ownership, it moved to the court, which is called the prize court. Thus, the prize court are the court especially constituted for the purpose of determining the validity of the maritime captured in the time of the war according to the international law. Now, what are the functions of the prize court? The main function, the general functions of the price code under the international law is to pass upon the price that is of the capture made by the belligerent. The landmark case in Zamora case 1916, Lord Parker stated that the primary duty of the price court is to preserve the rest means property, for the delivery to the persons who ultimately establish their title. After inquiry, the court may pass either a degree of condemnation when it decides that the capture to lawful price, or it may award the restitution with such compensation as may be appear just. So it may pass either degree of condemnation or maybe restitution. Restitution is awarded with the compensation in those cases where the capture state has sold the property seized, or if the captured property is lost through the fault or the negligence of the capture. The nature of price court. The price courts are the national courts and state laws grant them the jurisdiction. As such, this court is not an international court. Now, about the jurisdiction of the price court. The price could get their jurisdictions from those belligerent states which are involved in war and which established them. The belligerent states established the price court to provide the legality to capturing operations and capture goods by their decision. Price courts are state courts and state laws and state authority, and its declarations are applicable to them. Last, which law is applicable in the price court? Price courts are established by the belligerent in order to fulfill a duty imposed on them by the international law. It has been admitted by all the jurists that the price courts are the municipal courts, since they are maintained by a they are maintained just a minute by a single territorial sovereign. The law enunciated and applied is essentially the local law, but they are guided by the principle of the international law and therefore administer the international law. Therefore, they administer, let me correct it, administer the international. Okay, this is all about the price quote. You can conclude the topic yourself. Thank you all.